Welcome out to tonight's weekly members webinar, and I'm Michael Palmer filling in for Stephen and Shay tonight. And hope everybody's having a great week so far. And just wanted to give a brief shout out to my coaching student Alan for winning a really nice piece of land in the Franklin County, New York sale. Congratulations, and you did fantastically well. And so tonight, I wanted to touch on a subject that's kind of similar to what we talked about on last week's webinar. And, that is selling properties and deciding, whether we want to wholesale the property or sell it for the full market value. And so we're going to be talking about that in good, in deep detail and, discussing when we should wholesale the property, or when we should, take the property through a quiet title action to obtain a warranty deed. And so here, let's see. And so, we're going to be talking about tax lien foreclosures, tax deed foreclosures, when we should sell the property in as-is condition with a quick claim deed, or when it makes sense to sell the property with a warranty deed and take the property through a quiet title action. When we decide to take it through a quiet title action, or when it makes more financial sense to go ahead and sell the property in as-is condition, and a lot of things in between that I think will make a lot of sense. And so we're going to talk about tax lien foreclosures and also tax deed foreclosures and how they work and things like that. And so, once a tax lien has reached the end of the redemption period, then the lien holder can foreclose and get the property. And some states will assist in the foreclosure properties, like in Florida and also in South Carolina. These are self-executing states. And I especially like South Carolina because they only have a 1-year redemption period. And so if you buy a tax lien certificate on a property there, after the 1-year redemption period expires, if the previous owner doesn't redeem the property, then they'll automatically just send you a deed to the property, which is pretty awesome. And other states will generally require you to hire a local attorney to begin the foreclosure process in states like Arizona, Nebraska, and places like that. And these are non-self executing states, and so you will have to hire an attorney to file the foreclosure on your behalf. And so here is a tax lien example in Colorado, and we can see on this first example here at the top that the delinquent tax lien amount was only $7,774. And the assessed value from the county was $174,951, but Zillow has the value set much higher at $259,139. But either way, this was an absolute home run. And if you do get a tax lien certificate that doesn't redeem before, or if it, before the redemption period expires, and you're able to foreclose and get that property, this is where we get those type of deals where you literally get a property for, pennies on the dollar, as they say, or a very small fraction of what the property is actually worth. And the deed for this property was actually issued on October 13th of 2018. And then we have another great tax lien example as well as one that didn't redeem, and we can see that the total delinquent tax lien amount was $16,229, and the assessed value from the county was $244,879. But Zillow has an even higher value of the property for $338,647. And so once again, they absolutely knocked it out of the park with these deals. And 95% of all tax lien certificates are going to redeem before the end of the redemption period. But, in the event that they don't redeem, this is where you can really do exceptionally well. The tax lien certificates are a great place to park your money and earn the high interest rate of return, with a small chance that you may get to go ahead and foreclose and end up with the property. And so when you do, though, it's absolutely incredible. But, at worst case scenario, we're going to earn a higher interest rate of return, and it's a much better investment than you're going to typically get anywhere else, especially, in a COD, or as I call them, a certificate of disappointment that you would get at a bank or something like that, especially right now. And so with tax deed foreclosures, tax deed foreclosures are usually done by the county, but in some areas they may have a law firm that assists. In certain states, like in Texas, there's like 2 or 3 law firms that handle all of the tax sales for the entire state of Texas and file those tax deed foreclosures on their behalf. And with most tax deed sales, they're going to start the bidding at the amount of delinquent back taxes and fees. And then, of course, the highest bidder is going to win the property. And, tax deeds are usually offered first in an auction format, but for any properties that don't sell in their main auctions, they'll often, sell those properties over the counter as well. And that presents a great opportunity where, if we're willing to dig through a list of properties and pick out the ones that have value and use and do the research, we can buy them directly from the county without any competition. And, it's a great opportunity to pick up some properties. And especially with land, there's tons and tons of really nice land every single year that just gets overlooked in the tax sale auctions. And they don't even get a bid, and they go to the over-the-counter list, and then we can discover them and purchase them before anybody else does. So it definitely presents a really amazing opportunity if we're willing to dig through the list. And it's often a good idea to, after each tax sale, if they do put out an over-the-counter list, to try to, pick up the list as soon as it comes out and dig through it and pick out the best properties and purchase them before anybody else does. And so let's continue on here. And here are some Florida examples of some tax deed deals. And in the first one at the top, we have a single family home, 3 beds, 2 baths, and the value on it is about $52,500. And the winning bid at the auction was $10,100. And this one also has a rental value of about $900 plus per month. So that was a fantastic deal there. And also at the bottom there, we also have an additional single family home with 3 beds, 1 bath. And the value, of course, is $85,500. And the winning bid was $20,700. Again, with a rental value of about $900 plus per month. So these were fantastic buys as well in Florida. And Florida is a fantastic state to invest in because they have tax deed sales pretty much every single month in all the counties there. And they also have really good online, property records and GIS maps and official record searches, so we can do an investor title search. And it's pretty easy to do the research on the properties there in Florida fairly quickly, especially when compared to other states where it may be a little bit more difficult to get the information sometimes. And so that's one thing I love about Florida is, it's pretty easy to do the research pretty quickly. And also the properties there have a pretty darn high value as well. And the one thing I would say about Florida is they definitely have some of the highest competition, of almost any tax deed state. It seems like everybody wants a piece of Florida. But if you're willing to participate in a few auctions there, you can definitely win some properties. And I've had, a few students here in the last few months that have won some properties in Florida. So one approach you may want to take is putting a deposit in, 2 or 3 of the smaller counties, and just leave your deposit on file there with the county, and just bid in, each month when they have their tax deed sale, just continually bid until you win some properties. And that's using a location-based strategy that we definitely like to do. But if you do decide to bid in Florida, just realize that, there is a bit of competition and you may have to bid in a few sales before you win something. But on the flip side of that, it's very easy to get the information and do the research relatively quickly. So I definitely love Florida. And so, but what I wanted to talk about tonight is determining your exit strategy or your selling method for your tax deed properties, or maybe it's a lien that you were able to foreclose on. And once you receive the deed, you need to decide if you're going to sell the property in as-is condition or sell it with a warranty. And so if you're going to sell it in as-is condition, you'll be selling the property with a quitclaim deed or a tax deed. And if you're selling the property with a warranty, then you'll need to do a quiet title action in order to receive a warranty deed for the property. And so we're going to talk about both of these strategies and which ones that I prefer. And quite frankly, I do both of them. For certain types of properties, I'll definitely go ahead and wholesale them and sell them in as-is condition, just the same way that I got them from the tax sale. And for any properties that have a higher value or a little bit nicer, then I'll definitely consider taking those through a quiet title action to receive a warranty deed. And so first off, let's talk about selling properties in as-is condition, or wholesaling the properties, as we like to say. And so, let's talk about when to wholesale the properties and when does it make sense. And so selling a property with a quitclaim deed, we generally do that for properties that have a lower value below $20,000. Properties that are valued usually between $2,000 and $20,000. For those type of properties, it's usually a residential lot or maybe a little bit bigger piece of land. And since it has a little bit lower value than $20,000, it really may not make financial sense for us to spend $2,000 to $3,000 to file a quiet title action to obtain a warranty deed because the property doesn't have enough value. And so in those type of situations, it may make a lot more financial sense for us to just go ahead and wholesale it and sell it in as-is condition. And so just to kind of give you an example, let's say you had a residential lot that was valued at $12,000 at the full market value, and let's say you were able to pick that up for $1,200 to $1,500, so maybe right around 10 cents on the dollar. In that situation, it really doesn't make financial sense for us to spend an additional $2,000 to $3,000 to file a quiet title action because the property just doesn't have enough value. And so in those situations, we're just going to, go ahead and list the property for sale and sell it in as-is condition, and go ahead and find a buyer. And when we're wholesaling properties, we're generally going to sell them for a discount off of the full market value. And so, we want to give our buyers a little bit of a deal and pass on some savings so that, once they buy the property from us, if they so decide to take it through a quiet title action to obtain a warranty deed, they can afford to do so, and in many cases still come out with some equity in the property or have gotten it for a deal. And so in those situations, I'll usually wholesale it for somewhere between 50 to 70% of whatever the full market value is, just depending on how nice the property is. And I generally tend to list my properties a little bit on the high side, and that way it leaves me some room to negotiate once I get a potential buyer on the phone. And so let's say, I listed that property for $8,500, and I ended up finding a buyer, and they negotiated with me, and I ended up selling it for $7,500. And so in that situation, if I paid, between $1,200 and $1,500, I'm going to net profit somewhere between, probably around $6,000 essentially. And so it's a little bit of a smaller transaction, but I'm also able to do it a little bit quicker because I didn't have to wait out that time that it takes for the quiet title action to be completed, which is generally somewhere between 3 to 6 months. It can take a little bit longer in some circumstances, but that's generally how long it takes. And that's kind of based off of how backed up the court system is in that particular county that I'm filing in. And so, most tax sale wholesale properties are going to be vacant land and lots. And many times we call these cash deals unless we're offering seller financing. But many times we'll be doing the paperwork ourselves, Um, you can hire an attorney if you want to, but it's pretty simple to, complete all of the paperwork yourself, all the closing paperwork and the quitclaim deed transfer form, and submit all of that stuff. And we're going to be talking about that in a little bit more detail coming up here. Yeah, so we'll be selling the property without a warranty using a quitclaim deed or selling it in as-is condition. And so let's continue on here. And so here's the 3 wholesale steps for selling property in as-is condition with a regular quitclaim deed. And so we're going to go ahead and draft a contract or a purchase agreement. And generally, if the buyer is in another state or we're not able to meet up with them in person, then we'll usually send that to them for a digital signature. I like to use different websites like hellosign.com. I think they're Dropbox sign now. I think they merged with Dropbox, but it's essentially the same company. And I also will use signwell.com. And disclaimer, I'm definitely not affiliated with them or anything. I just like to use them because they give you 3 free digital signatures each and every single month. And so if I use up the first 3 free digital signatures from HelloSign, I can go to Signwell, and there's a bunch of other ones out there that you can find. I think there's one called like Panda Sign, and there's a bunch of other ones that you can find for free. But we're going to draft up a contract that says, I'm selling you this exact piece of land for the agreed price. I'm selling this property in as-is condition with a quitclaim deed, and then both parties will sign it. And if you do end up purchasing a contract template from one of these companies online, like Law Depot or Rocket Lawyer or something like that, just be sure to go in on the contract and make sure you read through it and change on there where it says warranty deed, because those come stock saying that you're going to give the buyer a warranty deed. And if you're selling it in as-is condition with a quitclaim deed, you definitely don't want to sign a contract that says that you're going to provide a warranty deed. Or they could, technically legally force you to go through a quiet title action and provide a warranty deed. So just be sure to read through all of that. But if we're selling it for a straight cash deal and not even doing seller financing, then, those contract templates are pretty cut and dry. Again, it just literally states that we're selling them this exact piece of land for the agreed price. They agree to pay in full. And once their payment clears, it says that we will transfer the deed or the title into their name as quickly as possible. And so, we're going to send that over to them. First, it's going to send it to our email address, and we're going to go ahead and digitally sign it. And then it'll send it over to the buyer for them to read and sign as well. And then it allows each party to print off a copy of the signed agreement with the digital signatures that are legally binding, of course. And then that way both parties have it, a copy for their records. And then the next step we're going to need to do is go ahead and collect their payment. We're going to talk about different payments that we can accept and things like that here in just a little bit. And then the final step in this process is we are going to record the deed in the new buyer's name. And we definitely want to find out exactly how the buyer wants that deed recorded. Do they want it in their personal name? Do they want it in their name and their spouse's name? Do they want it in the name of their business or some kind of a business entity? Do they want it in a will or a family trust? If they want it recorded in something other than their personal name, then they'll usually tell you exactly how they want it recorded. But we definitely want to find that information out so we make sure that we get the title transferred and the deed recorded correctly the first time. So let's continue on here. But yeah, here's a copy of a purchase agreement or part of one. And when doing a wholesale deal, you want to find a simple purchase agreement. I like mine to be as easy to understand as possible, but at the same time, make sure that we have all the correct clauses and things like that in the agreement. And most basic, purchase agreements are going to, have all of this stuff covered. And you can find many examples of contracts online that you can use. You can also, purchase one from a number of different companies like Law Depot and a bunch of other companies that offer those. Like I said, if you do buy one of those and you're selling with a quitclaim deed, make sure you change where it says warranty deed to quitclaim deed. And you want to fill out the document and sign it yourself digitally, or if you're physically able to sign it and then take it over to the buyer, then that's even better. But most of the time, you'll probably be doing some kind of a digital signature that is legally binding. And then go ahead and send it over to the buyer, and it's a pretty quick process to get done. And then both parties can go ahead and print off a copy for their records, and it's pretty much a simple process. And then once the buyer has signed the purchase agreement, you need to go ahead and collect their payment. And we can accept any form of legitimate payment that you feel comfortable with. So that could be a cashier's check, a money order, a wire transfer, personal check. We can even accept payments with all these different payment services that are out there now, like PayPal, Venmo. There's so many of them. One of the ones that I like to use as well is Zelle, or some people call it Transfer Zelle. What's great about Zelle is it transfers the funds instantly and there's no fees involved. And it also creates a record for both parties. And so for all of those reasons, I like to use Zelle, and especially when I'm collecting seller financing payments, it's so much easier to not have to wait or worry with the payments and things like that. So if your buyer has Zelle at their bank, and you have it at your bank as well, it's a very simple way to do things. What I'll generally do is have them, they can usually look you up through the Zelle app, using your phone number, or I believe it's your email address, and then it'll pop up your name. And then just to make sure that it's the correct person, I'll generally have them send like $1 or something like that, just to make sure that they have the correct person, and then they can go ahead and transfer those funds. But we can accept any form of legitimate payment that we want to, or we feel comfortable with. Just remember also, if your buyer is going to be sending a check, or especially if it's a personal check or something like that, we want to have them send it with some kind of expedited postage, because if they send it through the regular snail mail, then it could really delay the whole process for a while. The mail is kind of slow to begin with these days. And it could take a week or even longer sometimes for you to receive it with regular postage. And then you finally get their out-of-town check and deposit it, and then we have to wait for it to clear and everything else. And it just can drag things out a little bit. So if they are going to be sending a regular check, then definitely I'll encourage them to send it with some kind of expedited postage. And some people may only feel comfortable sending you a personal check, since it's very traceable and you have to wait for it to clear. And if that's what they feel comfortable with, then go ahead and accept their check if that's what you want to do. But just keep all of those things in mind when accepting payments. Definitely be sure to keep records of everything for tax purposes, and also your business records. And the next step, of course, we were talking about is recording the deed and transferring the title, and having the new deed recorded into the buyer's name. And so depending on the state, the deeds will need to be recorded in the Land Records Department. And it's usually one of 3 offices. It'll either be the county recorder's office, the county clerk's office, or the county court office. And they can have, other names like circuit clerk, chancery clerk, clerk of the courts, recorder's office. It'll be something like that. But we want to find out, whoever's responsible for recording the liens and deeds for that particular county, and reach out to them and find out exactly what their process is for them to transfer the deed for you. We're going to talk about that some more as well. And so all states will allow real estate to be transferred using a quitclaim deed form. And using a quitclaim deed is a very easy way to sell real estate when wholesaling a property. And with a quitclaim deed, we are transferring our interest or ownership in the property to another in as-is condition. And so, it's very, very simple to do this with a quitclaim deed form, and also just filling out some basic paperwork and submitting it to the county clerk's office. And so the first thing you want to do is find a quitclaim deed template. And there's plenty of them online that you can download for free. In fact, on eforms.com, they have a free quitclaim deed form for all 50 states. And so you can just literally type into a Google search, Mississippi quitclaim deed form, or Arkansas quitclaim deed form, or whatever state that you have the property in, and you can download one in just a couple of minutes. And the really great news about quitclaim deed forms is, they're generally pretty easy to fill out. Once you can do one quitclaim deed form, they're practically all identical in every state. And so, you'll see some of them are just slightly worded differently. And I've seen some of them that, ask you for your phone number and the buyer's phone number in the form itself. But most of them are just going to ask for some basic information. It's going to ask for your information at the top. And if the deed is recorded in your personal name, then you want to put your personal name on the top part of the form there. If it's recorded in the name of your business entity, then you definitely want to make sure that you put that on there, since you'll be transferring it from your business. And then, like we talked about earlier, we want to be sure and ask that buyer exactly how they want the deed recorded. Do they want it just in their name? Do they want it in their name and their spouse's name? Do they want it in some kind of a family trust or a will or their business entity? We want to find out exactly how they want it recorded. And you'll also need the buyer's address as well for this information. And then it just asks for, how much you sold the property to them for. And it's pretty basic information. And it actually tells you on the form, what pertinent information you need to fill in. So it's pretty self-explanatory. And then, there's like some lines. I should have put a bigger picture of this on here, but down here it even tells you, fill in the legal description. And so you're going to want to get your deed out and record the legal description exactly as it appears on your deed. And make sure you pay very close attention to detail, because if you make one tiny little mistake on there, some of these county clerks can be very, very picky, and they may reject your quitclaim deed form if you make one tiny error on there. In fact, I forget, it's one of the counties in Arkansas. One time I sold a property, and I had put like an E instead of a W or something like that. And the clerk actually called me up and said, Mr. Palmer, we're very sorry, but we're going to have to send everything back to you again. You'll have to start all over and resubmit all your documents. And I was like, well, what for? And they said, well, you put a W instead of an E or something, like west instead of east. And we ended up going back and forth, and I eventually convinced them to go ahead and transfer the title and issue the new deed into the buyer's name. And the only reason that they changed their mind was I had also written the parcel number of the property after the legal description. And so, in those lines there, I'll definitely fill in the legal description, but I'll also write in the parcel number. And the parcel number is just like the social security number of the property. It's a very identifying number. And since I had put that on there, and I just, convinced them it was a honest error, he finally went ahead and transferred it. So, but be very, very careful when filling these out, and make sure you cross your T's and dot your I's. And yeah, let's go back to here. And so also another thing I wanted to touch on as well with this is on the next page there, after you fill that out, it's got a bunch of legal jargon. It says, we'll transfer our interest or ownership or claim or title to the second party forever. And some of them have some interesting words in there, like to the behoof of the second party. I'm not sure what behoof means, but they have some interesting language, but it basically just says that we're transferring all of our ownership rights to the second party forever. And another tip that I would definitely give out when transferring with a quitclaim deed is always call up the county clerk and ask them if they have any additional requirements for them to transfer with a quitclaim deed. Most of the time we can just fill out the quitclaim deed form and send them a payment. Usually you have to send a check or a money order for the amount of the deed transfer fee. And so I always call them up and ask them, hey, how much is it to transfer this property with a quitclaim deed? How much do you charge? Who do I make the check payable to? It's almost always to the county or the county clerk's office or something like that, but I always want to find that out for sure. And then even though we can find the clerk's address online, while I have them on the phone, I'll also ask them, exactly which address do I need to mail this into? Because they may have a special room, like send it to our address here at the clerk's office, but it's room 1A, or they may say something like put attention so and so on there. And so we want to find out if they have any additional requirements to get the deed transferred. In certain states like Arkansas, we may also have to buy a real estate tax transfer stamp, but that seems to be only in Arkansas. So most states, we simply fill out the quitclaim deed form with all the information and mail it to the clerk's office. And then we're going to go ahead and mail off the deed. And, we're going to also, another thing I forgot to mention is you're going to fill out the quitclaim deed form, and then you need to go and find a notary public there locally and have the notary, you're going to sign the quitclaim deed form in their presence, and then they're going to go ahead and notarize the document, and they check your ID just to make sure that it's actually you and everything's legit. And then once we've got it notarized, like we were talking about, we always want to make sure that they don't have any other requirements for transferring the deed, like a cover sheet. One time I had a clerk that said, "Oh, you've got to do a cover sheet," and so I didn't know how to do it, so she had to email me over a template so I could create that. But that was kind of rare. But you just want to make sure they don't have any other requirements, and that we're doing everything the way that they want it done, so that we can get this over with and done successfully the first time. And the other thing we also want to include when we mail this off as well is a stamped envelope that's unsealed, providing postage. It's basically filled out to be mailed to the new buyer's residence. And what this is for is once the county clerk records the deed into the new buyer's name, they're not going to provide postage for us to have it mailed to the buyer. And so we want to make sure we provide some kind of postage so that once the clerk records the new deed, they can simply stuff it into the envelope and send it out with their outgoing mail. Occasionally, you may have a buyer that wants to, if they live nearby, go into the courthouse and pick it up from the clerk's office in person by showing their driver's license. And if that's the case, then you can just write a short little letter to the clerk's office and let them know that the buyer will be coming into their office to pick up the deed. But, I'd say 98% of the time, the buyer is just going to want to have the new deed mailed to their residence. But we want to make sure that we provide postage so that they can get it mailed to the new buyer. And, just like I said, make sure you just are very thorough, talk to the clerk, make sure that you are doing everything that they need you to do for them to successfully transfer the title and issue the new deed into the buyer's name, and then you're good to go. And so now let's talk about, selling properties with a warranty deed, or, going through a quiet title action, and, when we should do that. And so if a property has enough value, it's definitely worth the money to go ahead and go through a quiet title action and get a warranty deed. And, generally that's going to be for properties that have a value above $20,000, and especially if it's, $25,000, $30,000 or more than that, it definitely makes financial sense for us to go ahead and take it through a quiet title action so that we can obtain a warranty deed so that we can then sell the property for the full market value. And having a warranty deed will mean that any title company can then issue title insurance on the property, and then our potential buyers can get a loan from traditional lenders like a bank or something like that. If they wanted to purchase the land from us and also build a home on it, they'd be able to go ahead and get traditional financing to do that. And so that's why we want to take it through the quiet title action. And it's going to be a different kind of buyer than the type of buyer that's going to buy a wholesale type property. People that are buying from us in properties in as-is condition are usually, the type of person that's looking for a deal, and maybe they're a hardworking person, but they don't make quite as much, and they, but they still want to own some real estate outright, and so they're willing to go ahead and purchase the property from us in as-is condition. But people that with these higher valued properties that are a lot nicer, especially we're going to be charging a lot more for them as well. They're generally going to want to go to, a bank or something like that to get, funding to go ahead and purchase the property from us. And so, like I said, it's going to generally be done on properties that have a value of $20,000 or higher. And going through that quiet title action process is generally going to take, between 3 to 6 months to complete. And so we touched on this last week when I was talking about filing quiet title actions and what they are, but I'm going to go over it briefly again here. A quiet title action is a legal proceeding or a lawsuit that we file to establish an individual's right to ownership of real property against one or more adverse claimants. And quiet title is the court process you go through to have the tax deed legally turned into a warranty deed. And we generally do this when we want to sell the property for the full market value. And so, and just like we were talking about, a quiet title action is a lawsuit that is brought in circuit court to clear a party's title to real property. And so basically, they're going to, look up anyone and everyone that had any kind of interest or claim to the property whatsoever of any kind, whether it was from a family trust or through a will or any kind of claim. It could be a bank that had a mortgage on the property or anything like that. And it's already gone through the tax sale foreclosure, but and so these people have already been notified multiple times that the property was going to the tax sale. Please come step forward and pay the property taxes. And at this point, it's essentially too late, but they're going to serve them with notice one more time and say, hey, if you're going to try to make any kind of claim to this property, step forward or forever hold your peace. And they also have to go through some other legal processes. They have to advertise it in the local newspaper for so many weeks, and they have to go through a few different legal things. But basically, once they take it in front of the judge and present to him that everything was done correctly when the tax sale foreclosure was completed, and that they've satisfied everything, all the legal requirements for the quiet title action, then the judge will sign off, and with one swipe of his pen, he clears that title and issues a full warranty deed to the property. And so, like I was just discussing, the purpose of a quiet title action is to eliminate any claims to the title, which might stand in the way of the title of a title insurance company issuing a clear title insurance policy. And so, all liens, claims by prior owners, and any other matters affecting that title are called clouds on the title. And so the whole purpose of a quiet title action is to eliminate any of the clouds on the title. And so each state has different laws and regulations concerning quiet title actions, and some states may have quiet title statutes, and other states allow courts to fashion most of the laws regarding quiet title actions. And exactly who is able to file a quiet title is going to depend on that state's rules, but in all states, tax sale investors have the right to go through a quiet title action and obtain a warranty deed to the property. So, if you're going to be looking at filing a quiet title action, I would definitely call around to some local real estate firms and just get some quotes on how much they would charge to file a quiet title action. And, you definitely don't have to go with the most expensive lawyer or firm out there. From what I understand, these are pretty simple to file, and pretty much any real estate attorney should be able to do it. So I would, definitely go with the lowest price that you can find and save yourself a few bucks there, unless you find someone that can possibly get it expedited and push through a little bit quicker. But beyond that, I would go with the least expensive attorney that you can find to file this. And let's see here. And so, yeah, just like we were talking about earlier, all potential defendants, in this case, are going to be past owners, are going to be notified by certified mail. But of course, they've been notified, multiple times over a period of years before it went to the tax sale that they were delinquent on their taxes. So this will be nothing new to them. At this point, they've lost the property and all rights to the property since it went through the tax sale foreclosure. But they're just saying, step forward if you think that there was any part of the tax sale that wasn't done properly, or you didn't receive notice, there's really no way that they could make that claim because, they have to sign off multiple times by certified mail that they were served notice of the upcoming tax sale foreclosure. And so the chances of them being able to do that are pretty much slim to none. And also, if they were to try to make some claim that something wasn't filed correctly in the tax sale foreclosure, they'd have to be able to actually prove it. And they're also going to have to hire an expensive attorney to, file that on their behalf. They're not just going to be able to step forward and say, I make a claim. They'll have to have a very legitimate claim. And so, again, the chances of that happening are less than 1%, if that. And so, but anyhow, once the notices have been mailed out, the past owners will each have 20 days to respond from the date that they are served. And if no party responds or if no one disputes the quiet title lawsuit, then the process will be considered defaulted. And in most cases, a motion for final judgment will be filed with the court. And in that case, like we were discussing earlier, the judge will sign off, and with one stroke of his pen, he will clear the title to that property and issue a warranty deed. And so the cost of a quiet title action can really vary based on the exact situation in the state. And like we were talking about, there's publication fees. They still require in a lot of states, there's still a law on the books that they have to publish a notice of the quiet title action in the local newspaper. And, there's just a bunch of formalities that they have to go through and steps they have to do in order to file these. And also, it also is based on the number of potential defendants or, anyone who was a previous owner or had any kind of claim or interest to the property previously before the tax sale. And generally law firms can charge anywhere from between $1,000 to $3,000 to file a quiet title action. So, like I said, I would definitely shop around and try to find, the least expensive price that you can to get it filed. And this process is generally going to take anywhere from 3 to 6 months to complete. And again, that's usually based on how backed up the court system there is in that particular county. And so they can usually, an attorney can shine some light on approximately how long it's going to take for them to get it completed. And, if the very last owner had a warranty deed to the property and they were the only sole owner where there wasn't very many parties involved, it's usually a very simple quiet title action for them to file. But if there was multiple people that had some kind of claim or interest to the property previously, and there was some other transfers with something besides a warranty deed, all these things that are clouds on the title, the more complicated it is, usually the more expensive it's going to be. And so, there's also a couple of different ways that we can possibly get title insurance. And so, we can locate a law firm within the county where the property is located. And you can usually just do a basic Google search and find some different law firms and just call around and get some quotes and get an idea of, what the going rate in that particular county is, and, find the best price that you can. And you can use Yellow Pages, online websites, and different directories. There's, AVO or AVO. I mean, there's so many different places you can find an attorney these days. And, we definitely want to focus on law firms that practice real estate law. And just like we were talking about, you definitely want to check with a few different law firms to determine the best bang for your buck or the lowest price that you can find to get this filed. And another option that we have as well is we could look into other companies that can, provide title insurance without necessarily having to go through a quiet title action. And there's a company called Tax Title Services or taxtitleservices.com. And basically what they can do is they work with tax deed investors, and they'll look at the title to the property, and they can often offer title insurance without you having to actually go through a quiet title action. In some cases, they can be a little bit more expensive than possibly filing a quiet title action, but the upside to it is they can, get you title insurance much quicker so that you can go ahead and sell the property for the full market value, and your buyers can go and get a loan from a bank or traditional financing. And these companies, there's Tax Title Services, and there's also one called cleartosell.com as well, that essentially does the same thing. And so definitely check them out. You can certainly get a quote and see how much they would charge to offer you title insurance, and it would be a much quicker process than going through a traditional quiet title action. And once we have title insurance, that qualifies for financing usually in under 30 days. And sometimes they can get it done in 2 or 3 weeks, go ahead and get you title insurance. So definitely check into those companies as another option as well. Yeah, here they are, taxtitleservices.com, and they've been around for years now, and they definitely have a very good reputation. They're going to know exactly what you're talking about. They work directly with tax deed investors or tax sale investors, and usually for $2,300-$2,500 somewhere in there, they can go ahead and get you title insurance on most properties. And there's also cleartosell.com, and they can get title insurance in 20 days. It looks like they may be a little bit more expensive, and I'm not sure if Clear to Sell can do all the states or not. I know at one point, Tax Title Services, there was a few states that they didn't work in, but I think they may have expanded now, because I was looking at their website the other day, and it looks like they're definitely doing more states. But it's certainly worth looking into, because it's a much quicker way to go ahead and get title insurance. And so that basically concludes everything. But based off of the value of the property itself and how nice it is and the type of property is going to determine what our exit strategy is. If it has a value of $20,000 or less, in most cases it's going to make the most financial sense for us to just go ahead and wholesale it, sell it in as-is condition. And those are a little bit smaller deals. You'll generally net profit somewhere in the ballpark of $5,000 to $10,000. You certainly can make a whole lot more than that with wholesale deals or selling it as is condition. But they're a little bit smaller deals, but we can also do them much quicker. And so that's one thing to take into consideration. And then when we're able to win properties that have a much higher value, it's going to take a little bit longer to complete those deals when we go through that quiet title action process. But, in the long run, we're going to hit some huge home runs and make, usually very large sums off of one deal in those type of transactions. And so I like to do both types of deals myself. I will do some small deals. If I win properties that are valued below $20,000, I'll just go ahead and wholesale them with an as-is condition with a quitclaim deed. And then when I'm able to win the higher valued properties or pieces of land that are valued, especially if they're $25,000, $30,000, $40,000 and above, it may take me a little bit longer to complete those type of deals, but I'm also going to be making large sums of profit off of those type of transactions. And so anyhow, hopefully that all makes sense, and it'll kind of open your mind to the different exit strategies that we can implement, especially when it comes to land. When it comes to houses, almost all houses should have a value above $20,000. Unless it's a trailer, an old modular home or something like that. But with a house, it almost always makes sense to go ahead and do a quiet title action. But with land, those are the two different exit strategies that we can implement. And, just depending on which one we want to do, I like to do them both. When I do some smaller deals, I may have to do a few of them to make the same amount of profit that I would off of one bigger deal, but I'm able to complete them a little bit quicker. And so, when I go to tax sales, of course, I've bid on the highest valued, nicest land and properties. And if I get outbid, then I will go after some of what I call the lower hanging fruit. And I will still pick up some land that may not have necessarily been the ones that I wanted the most, but I know that I can still turn around and sell them and make a profit. And so that way I'm bringing home something to sell instead of walking away with nothing. And then in those situations where I'm able to win those much higher valued properties and not overpay and get them for my max bid or lower, then it may take me a little bit longer to complete those transactions when I go through a quiet title action. But nonetheless, when I turn around and sell them, I'm also turning quite a large profit off of those type of deals. And so hopefully that all makes sense. Let's see here. And so, yeah, let's look at a couple of questions here. Will these slides be available on the website? I'm not sure. In fact, I believe Stephen and Shade are going to be coming out with a new version of the website soon, but we will have the replay of this coaching session in the weekly members webinar webinar replay. So you can certainly watch this again and let it sink in just a little bit. And also, if you have any questions, you can always let us know. We'll be happy to answer those for you. What does this other one say? Would you say AKA before the parcel? Before the parcel number. I believe that's also known as, Alan. I believe that's also known as, and so maybe I saw that in another sale in New York that I was looking at, and it had two parcel numbers, and I plugged in the older parcel number into the GIS map, and it wasn't pulling up, and then it said, AKA or so, it had some other 3 digits similar to that, and it had a second parcel number. And so I put in the second parcel number, and it did pull up that property that it was showing. So I'm assuming that they may have assigned it a second parcel number. I'm not sure why they would do that, but I did see that the other day, which was quite strange. Let's see. Does anybody else have any other questions about all of that stuff? Does it all make sense? Because I just wanted to make sure everybody kind of understands the two different strategies, when to wholesale, when to take it through a quiet title action. I guess that's it. Awesome. Well, I hope everybody enjoyed the webinar tonight, and yeah, hopefully that all made sense for everybody, and definitely let us know if you have any questions. And also, I would definitely recommend for you to start digging through the list of some of these upcoming auctions. There's quite a few sales happening in Utah, New York, Virginia, South Carolina. There's a bunch of different sales coming up, and it's just going to continue to pick up more and more as we head further towards the summer. And there's going to be tons of great opportunities out there, not only with the online auctions, but also live in-person sales, if you could possibly attend some of those. We can also, after a lot of these sales, there may also be some fresh over-the-counter inventory coming out that we can take advantage of. And it's just going to pick up, and there's going to be a lot of great opportunity this year. And so we definitely encourage you to get registered for some of these online auctions and just participate in some of these sales, because as they say, you have to play the game to win. And so you have to get in there and go for it and start bidding in some of these auctions. And I certainly understand that it can feel a little bit frustrating when you're first starting out. You learn how to do all the research steps, and you do a lot of work, and then you participate in a sale or two and maybe get outbid. Getting outbid is part of the process, but I never look at it as a loss if I don't win any properties. I always look at it as, I learned a tremendous amount. I learned about a certain county in a certain state, and I become more familiar with that. And next time I can come back and have a little bit easier time finding the information, and I'll know a lot more about it, that particular county and how they operate. And also, you're just that much closer to winning on your next property. Why is California discouraged than other states? We definitely like California, and they have some great opportunities there. Some of their sales there can have a good bit of competition sometimes, and things may bid up rather high, but California is fantastic. Definitely dig through some of their sales, and if that's an area that you're interested in possibly purchasing some properties, just be open to bidding in a few sales there in case you get outbid in the first one or two, and just stay consistent, and you will definitely win some properties. But that's what I would recommend for people to do is, learn a particular state or even a particular area or county. And then once you kind of figure out how to get all the information and how everything works there, then it'll be much easier to go back and participate year after year. And also, if you find certain counties or certain states that you like to invest in, that's exactly what I do. Is I have a calendar laid out literally of many different states that I like to participate in year after year. And, of course, I have my favorite counties in those states, and I've been bidding there for so long that I'm very familiar with those counties now. I can easily get the information, and some of these areas I can just eyeball properties and tell if a piece of land is buildable, just because I know how the minimum lot size requirements, all of the setbacks and all of the other information. So anyhow, folks, hope you all have a great rest of your week, and let's get into some of these auctions and keep us posted as to how things are going, and let us know if you have any questions, and we'll talk to you soon. Thanks.